Honorable members, I received a report from the committee and is also a minority report. So we'll hear from the chair of the committee, and then we'll also give a chance to a member of the minority report. Madam Chair. Madam Chair. Honorable members, please listen to the chair when she's presenting her report. Sarah, you can carry the handbag on. We are taking a record of all the members that are around. We will publish the members who are in the House.
Madam Speaker and the House, on behalf of the Legal and Parliamentary Affairs Committee, I would like to present the report of the Sector Committee of Legal on the Anti-Homosexuality Bill 2023.
Please speak to the microphone. Honorable, there is a seat here.
Madam Speaker, like you alluded to, under Rule 205 of our rules, there is a minority report authored by 2 members of my committee and which shall be read by them. I beg to lay the report of the committee and the minority report and the minutes of the meetings of the committee.
Please lay. Thank you.
Thank you, Madam Speaker. Madam Speaker, I'll read the executive report. On Thursday, 9th March 2023, a bill entitled the Anti-Homosexuality Bill 2023 was, in accordance with Rule 128 of the Rules of Procedure of Parliament, read for the first time and referred to the Committee on Legal and Parliamentary Affairs for scrutiny. The bill is a private member's bill sponsored by Honorable Basalira Asman, MP, Bugiri Municipality. The object of the bill is to establish a comprehensive and enhanced legislation to protect the traditional family by A, prohibiting any form of sexual relations between persons of the same sex and the promotion or recognition of sexual relations between persons of the same sex. B, strengthening the nation's capacity to deal with emerging internal and external threats to the traditional heterosexual family. This legislation further recognizes the fact that same-sex attraction is not an innate and immutable characteristic. C, protecting the cherished culture of the people of Uganda, legal, religious, and traditional family values of Ugandans against the acts of sexual rights activists seeking to impose their values of sexual promiscuity on the people of Uganda. And D, protecting children and youth who are made vulnerable to sexual abuse through homosexuality and related acts. The bill seeks to address the gaps in the provisions of other laws in Uganda, for example, the Penal Code Act Cap 120, which has no comprehensive provision catering for homosexuality and majorly focuses on unnatural offenses under Section 145, and lacks provisions for penalizing the procurement, promoting, disseminating literature and other pornographic materials concerning the offenses of homosexuality. As a result, there's a need for a legislation to enhance offenses relating to homosexuality and clear provisions for charging, investigating, prosecuting, convicting, and sentencing of offenders. The legislation seeks to supplement the provisions of the Constitution of the Republic of Uganda and the Penal Code Act Cap 120 by criminalizing same-sex marriages. Article 31 of the Constitution recognizes that men and women of the age of 18 years and above have the right to marry and to found a family and are entitled to equal rights in marriage, during marriage, and at its dissolution. In the same vein, the Constitution recognizes the cultural diversity of Uganda, and in Article 37 of the Constitution, recognizes that every person's right to belong to, enjoy, practice, profess, maintain, and promote any culture, cultural institution, language, tradition, creed, or religion in community with others. The Constitution of the Republic of Uganda contains in Chapter 4 a Bill of Rights, which guarantees and protects a number of rights and freedoms. The rights recognized and protected in the Constitution are enjoyed by all persons in Uganda. The Constitution of Uganda does not recognize a right to homosexuality, but instead bans and prohibits same-sex marriages. Uganda enjoys rich cultural diversity, and although all are richly different, they do not recognize same-sex relations. Whereas some few individuals have existed with such tendencies, these were isolated by society and in some cases punished for such unnatural acts. The prohibition against homosexuality is entrenched in the laws of Uganda and our cherished and shared cultural norms and values. Whereas homosexuality as an offense already exists on the law books under the Penal Code, there is need to redefine the law, placing emphasis on the new law and emerging matters which are not contained in the Penal Code Act, such as promotion of homosexuality and the recruitment of children into homosexuality, which have been blamed for the rising incidence of homosexuality in Uganda. Whereas Uganda is a signatory to a number of international instruments that might be interpreted to recognize sexual minorities, these do not legally create binding obligations on Uganda, since the Constitution, which is the supreme law of Uganda, and other enactments such as the Penal Code Act specifically bar sexual acts between sexual minorities. There are emerging matters which are currently not provided for in the bill, but need to be considered. The committee recommends that the Anti-Homosexuality Bill 2023 be passed into law subject to the proposed amendments. Right Honourable Speaker and Honourable Members, I beg to report.
Thank you so much, Honourable Chair of the committee. We've had a report from the chairperson. Can we have the minority member? Honourable members, as we agreed, we legislate for everybody. Let's allow the minority member to present, and then please, silence. Please.
I thank you, Right Honourable Speaker and Honourable Members.
Honourable Fox, you're protected. Please present your report.
I thank you very much, Right Honourable Speaker.
Order, Right Honourable Speaker.
Right Honourable Speaker, please permit.
Somebody.
Order.
Yes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the rules of the sitting of this House are very bold and clear, that the front bench is specifically for ministers. Right Honourable Speaker.
Fiona, you want to take over the position of a speaker today?
No, Right
The
Honourable
speaker had already made a ruling. I wouldn't allow members to stand when there was free space in member.
Much obliged, Right Honourable Speaker.
Honourable members, can I hear from Honourable Fox? Okay. Procedure matter.
Thank you, Right Honourable Speaker. Madam Speaker, our rules of procedure provide for a minority report if you have areas you don't agree with the majority. I see a member who is presenting the minority report has signed on the majority report. Has signed both the majority report and the minority. Yes, I have the report on my iPad. Are we proceeding right, Right Honourable Speaker, that a member signs both reports, the majority and the minority? What does it mean? Are we proceeding well? Madam Speaker.
Honorable members, you're debating in anticipation. I have a report here. Honorable Fox Odoi has signed on one report, the minority report. The report here, the major report, is not signed by Honorable Fox Odoi.
Right,
Now,
Honorable Speaker.
honorable members, I have the original copy. I will investigate what is on the iPad. Fox. Yes,
Thank you, Right Honorable Speaker. Thank you, Right Honorable Speaker. Right Honorable Speaker, I'm a member of the Rules and Privileges Committee. And in our discussions, the chairman of the Rules, we may now guide here, but the chairman of the Rules Committee has guided that if a member of a committee agrees with a lot of things in a majority committee and only disagrees on only a small part, it doesn't stop that person from signing that report, the majority report, and only highlights the area of disagreement.
honorable members, honorable members, honorable members, honorable members, can I have order? Can I have order in the House? I have ruled, I have made a ruling, and I will stand by that ruling. Honorable Fox did not sign. Let's hear his area of dissent.
Procedure.
I thank you for your wise ruling. Right Honorable Speaker, for the record, the minority report is signed by 2 members of the Legal and Parliamentary Affairs Committee, the Honorable Kwizera Paul, Kisoro Municipality, and myself. Right Honorable Speaker, you will permit me to skip the introduction of the bill, and I go straight to the points of dissent.
Please.
I thank you, Right Honorable.
Honorable members, in the VIP gallery this afternoon, we have Bishop William Tom Sange from Joy Christian Center Churches, Michiana District. We have, you're most welcome. Thank you for joining us. Can you tell us your areas of dissent?
Thank you, Right Honorable Speaker. And Right Honorable Speaker, I should go on record. I did not sign the majority report.
That's very good. Go ahead.
Yeah. Right Honorable Speaker, point number 3.1. The title is, "The Bill is Misconceived." Right Honorable Speaker, the explanatory memorandum of the bill indicates that the intention of the bill is designed to address gaps in the provisions of other laws in Uganda. For example, the Penal Code Act, Cap 120. The explanatory memorandum further indicates that the Penal Code Act, Cap 120, has no comprehensive provisions catering for anti-homosexuality, since according to the bill, the Penal Code Act focuses on unnatural offenses under Section 145 and lacks provisions for penalizing the procurement, promotion, dissemination of literature and other pornographic materials concerning the offense of homosexuality. Right Honorable Speaker, this is not a factual statement, since we all know that homosexuality is an offense proscribed in Section 140 of the Penal Code Act, which we reproduce here below. Section 145. 145, the subtitle is unnatural offenses. Any person who, A, has carnal knowledge of any person against the order of nature, B, has carnal knowledge of an animal, or C, permits a male person to have carnal knowledge of him or her against the order of nature, commits an offense, and is liable on conviction to imprisonment for life. The above section, Right Honorable Speaker, please protect me from the Honorable both of both. The above section specifically prohibits and punishes. Right Honorable Speaker, the above section specifically prohibits and punishes conduct of a person who has carnal knowledge of any person against the order of nature, and the conduct of a person who permits a male person to have carnal knowledge of him or her against the order of nature. This provision has been in our penal code for a millennia. Right Honorable Speaker, the explanatory memorandum also indicates that the penal code focuses on unnatural offenses under Section 145 and lacks provisions for penalizing the procurement, promotion, disseminating literature and other pornographic materials concerning the offense of homosexuality. This is also not true, since the provisions of Section 145 criminalize, in addition to homosexuality, sexual acts between animals and human beings. In addition, the Penal Code Act has comprehensive provisions that deal with penalizing the procurement, promotion, disseminating literature and other pornographic materials concerning the offenses of homosexuality under the general prohibition on conspiracies in Chapter 16 of the Penal Code Act, Cap 120. Conspiracy to commit felony, conspiracy to commit misdemeanor, and other conspiracies. For instance, Right Honorable Speaker, courts in the case of Nabagesera and 3 others versus the Attorney General and another, miscellaneous cause number 33 of 2012, recognized that the actions of the petitioners in organizing a workshop advocating for normalization of minority rights in Uganda was a conspiracy, since it engaged in direct or indirect promotion of same-sex practices, which is prohibited under the Penal Code Act. This means that acts that tend to promote homosexuality can be dealt with conclusively under the Penal Code Act. We, the minority, surmise, therefore, that this bill was introduced under the reasonable but mistaken belief that the Penal Code Act is not sufficient to deal with matters related to homosexuality. It was introduced during a time when anti-homosexual sentiments have been whipped up across the country and is not based on any factual or evidential value to show incidents of homosexuality have increased and require additional legislation. Right Honorable Speaker, according to the annual crime policy reports, incidents of homosexuality have been reducing in Uganda. Right Honorable Speaker, in 2017, the police in Uganda recorded a total of 120 cases of homosexuality. In 2018, the number recorded was 100. 2019, 103. 79 cases were reported in 2020, and 80 cases were reported in 2021. 2022 recorded 83. This means that the legislative interventions sought are not backed by any evidence of increase in this particular crime.
Order, Madam Speaker. Order.
3.2.
Order, Madam Speaker.
Can you finish?
Order.
3.2.
Order, Madam Speaker.
3.2, Right Honorable Speaker. Criminalization of appearance of a person. The second point of dissent is that the bill, in its current form, creates penal sanctions against a person merely based on appearance, thereby attempting to reverse the decision in the court case of Kasha Jacqueline versus Rolling Stone Limited and another, miscellaneous cause 163 of 2010. Right Honorable Speaker, the minority are aware that Clause 2(1)(d) of the bill proposes to declare as acts of homosexuality a person who holds out as a lesbian, gay, transgender, a queer, or any other sexual or gender identity that is contrary to the binary category of male and female. This provision has the effect of criminalizing the persons who identify as lesbians, gay, transgender, queer, or any other sexual or gender identity that is contrary to the binary categories of male and female, without such persons committing any offense under the laws of Uganda. The committee was also informed by the Uganda Medical Association that in Uganda there are rare biological cases affecting the genes that code for unusual expression of physical phenotypic expressions associated with genital organs. These include Klinefelter syndrome and random genetic occurrence.
Clark, can I have more chairs inside for members? Can you summarize?
Right Honorable Speaker, the third point of contention at 3.3, and I'm trying to run through a rather long report, 11 pages.
No, you take your time.
I take my time.
Take
Thank
your
you.
time.
Thank you. Right Honorable Speaker, the DPP cautioned the committee about clauses 1(2)(d), which seeks to punish a person based on appearance, and reasoned that if a person holds out as a thief, he cannot possibly be punished for being a thief until he commits the crime of theft. The minority are aware that the following police conduct, that the police conduct in Victor Mukasa, I beg your pardon, Right Honorable Speaker, the minority are concerned that the police has been arresting people based on their appearance, as was found in the case of Victor Mukasa and another versus the Attorney General. High Court Miscellaneous Cause number 24 of 2006, where the plaintiff in that case was arrested by police based on appearance and without having committed any offense, and taken to the police to determine his sexuality. The minority are aware that following police conduct in Victor Mukasa, Supra, court guided in the case of Kasha Jacqueline versus Rolling Stone and another, miscellaneous cause 163 of 2010, that, and I quote, the scope of section 145 of the Penal Code is narrower than gayism generally, that one has to commit an offense under section 145 to be regarded as a criminal. This decision means that being or appearing as a person belonging to LGBTQ plus person is not in itself an offense until the person commits any of the offenses prohibited under our laws. This means that a person cannot be criminalized, but the conduct of that person can be. Right Honorable Speaker, the third point of dissent is duplication of provisions in the Penal Code Act. The minority notes that the majority of the stakeholders who appeared before the committee pointed out that the bill introduces nothing of practical value, but merely reproduces provisions that already exist in other laws. Whereas the majority of the clauses in the bill are unconstitutional, the rest are redundant, and they become useless once the unconstitutional provisions are removed. The redundant clauses include Clause 5(2), 4, Clause 7, 9, 10, 11, 13, 15, 16, and 17. The bill is a duplication of the provisions that already exist under the Penal Code Act and is therefore unnecessary. The DPP also objected to the bill on grounds that the proposals contained in the bill should be introduced if they are found relevant in the Penal Code rather than being introduced in the proposed bill. The Attorney General advised the committee and pointed out a number of provisions that are already prescribed in our laws, making the bill redundant and of no legislative value. The minority find the following provisions redundant. Clause 1 defines matters that are already provided in other laws, including the Penal Code Act. Clause 1 on the offense of homosexuality is provided for in Section 145 of the Penal Code Act. Clause 2 of the offense of aggravated homosexuality can be prevented in Section 129 of the Penal Code Act on the offense of defilement. Clause 4 is already prescribed in Clause 146 of the Penal Code Act. Clause 7 is well entrenched in Article 28 of the Constitution, which gives judicial discretion to a court or a tribunal to exclude the press or the public from all or any proceedings before it for the reasons of morality, public order, or national security, as may be in a free and democratic society. Clause 8 is already provided for in Section 19(1)(c) of the Penal Code Act. Clause 9 of the bill exists in Chapter 16 of the Penal Code Act. Clause 11 is already provided for under Section 134 of the Penal Code Act. Clause 13 is redundant since Article 31(2) specifically bans same-sex marriages, and the Marriage Act defines a marriage and does not include same-sex marriage. Clause 16 is redundant. There exists a law to regulate extraditions from and to Uganda, and that law is the Extradition Act, Cap 117. The minority are aware that the provisions of the bill, once passed into law, will complicate the prosecution of offenses under the Penal Code Act. The committee was cautioned by the Attorney General that there's nothing that prevents Parliament from enacting laws or indeed improving on existing provisions of the law to meet emerging challenges in or of the society, as long as Parliament cautions itself against duplication of provisions in other laws. Our last point of dissent, Right Honourable Speaker, our second last point of dissent, the constitutionality of the bill. The bill makes provisions for matters which infringe the Constitution of the Republic of Uganda, 1995, including Article 27 on the right to privacy, Article 24 and 44A relating to non-derogable right to freedom from inhuman and degrading treatment as protected under Articles 24 and 44A, Article 21 of the Constitution on the right against discrimination. The bill goes beyond the limitations envisaged in Article 43 of the Constitution, and some provisions contravene the principle of legality prescribed in Article 28(12) of the Constitution. Right Honourable Speaker, not only does the bill contravene the provisions of the Constitution of the Republic of Uganda. It also contravenes established international and regional human rights standards, as it unfairly limits the fundamental rights of the LGBTQ plus persons. This criminalization, Right Honorable Speaker, denies them equal protection under the law owing to the harsh and differential treatment they receive based on their sexual orientation and criminalization of the same. The provisions, Right Honorable Speaker, the provisions that further infringe the Constitution also include Clause 3(1)(b) and (c), which make the offense of homosexuality aggravated when the offender is a person living with HIV and when the victim is a person with disability. And we propose that that would violate Article 21 of the Constitution because it's discriminatory. The discrimination on the basis of HIV status and being a person living with disability. These provisions perpetuate the stereotype that people living with HIV cannot engage in safe adult-to-adult sex, that people with disabilities are eminently victims in human relationships. B, Clause 5(1), Right Honorable Speaker.
Honorable members, please respect the member.
Clause 5(1), which provides that a victim of homosexuality shall not be penalized for any crime committed as a direct result of his or her involvement in homosexuality, combined with the definition of victim in Clause 1 as including a person who is involved in homosexual activities against his or her own will, introduces the homosexual panic defense, which essentially gives the victims a leeway to harm suspected LGBT persons and get away scot-free, thereby contravening the presumption of innocence guaranteed under Article 28(3)(a) of the Constitution. C, Clauses 1, 2(1)(d), 3(1)(b), E, F, 4(1) and 8, in as far as they define touching as constituting the offense of homosexuality, aggravated homosexuality, attempt to commit homosexuality, and aiding and abetting homosexuality, respectively, would violate the principle of legality under Article 28(12) of the Constitution. This provision requires that all criminal offenses be properly defined and is part of the non-derogable right to a fair hearing protected under Article 28 and Article 44(c) of the Constitution. Court has declared provisions of laws that are incapable of exact definition unconstitutional. It's therefore the position of the minority that the provisions in the bill, if passed into law, infringe the rights of Ugandans, specifically the rights and freedoms of expression, association, liberty, privacy, equality and freedom from discrimination, inhuman and degrading treatment, the right to a fair hearing, and finds that if Parliament enacts this into law, it will be unconstitutional. 3.5. Right Honorable Speaker, some of the we also argue that the bill reverses the gains registered in the fight against gender-based violence, especially against women and girls. some of the clauses of the bill,
Honorable members, can we
Right Honorable Speaker,
give him time to finish?
some of the clauses of the bill reverse the gains registered in the fight against gender-based violence, especially of women and children. The bill in clauses 2 and 3 makes provisions for the offense of homosexuality and aggravated homosexuality. The provisions prescribe sanctions for 10 years against a person who infringes against the provisions of the bill. The minority has examined these provisions and finds them to infringe on sections 123, 129 of the Penal Code, which create the offenses of rape, and defilement respectively. These offenses prescribe varying sentences against persons who conduct themselves or herself in a manner that constitutes the offense, ranging from death to life imprisonment. The bill now proposes to make various indirect amendments to those provisions of the Penal Code by reducing the penalties for the same conduct that is prohibited under sections 123 and 129 of the Penal Code from death and life imprisonment to 10 years imprisonment. This makes the provisions regressive, affects the fight against gender-based violence against girls and women, and reverses the gains so far registered in the fight against rape and defilement. In conclusion, Right Honorable Speaker, the minority have examined the bill and are of the considered opinion that the bill is ill-conceived. It contains provisions that are unconstitutional. It reverses the gains registered in the fight against gender-based violence. It criminalizes individuals instead of conduct, and that contravenes all known legal norms. The bill does not introduce any value addition to the statute books and available legislative framework. In light of the above, the minority proposes A, that the spirit of the anti-homosexuality bill guides the enrichment of a comprehensive, non-discriminatory sexual offences bill. B, that the proposals contained in the bill should be presented to the Law Reform Commission to study and advise government on the possible reforms of sexual offences laws. C, that government should introduce legislation and a framework for the provision of rehabilitation of victims of sexual and gender-based violence. D, that the existing legislation be amended to provide clarity where necessary. Right Honorable Speaker, I beg to report.
Thank you. Honorable members, I want to thank the minority member, and I will give time. Honorable members, once we open the debate, we are going to structure the debate in this way. Those who are not in favor of the bill will also get up and speak, like he has spoken. We start with them. Then we will know who is who. But meanwhile, a motion?
Procedure.
Proceed.
Madam Speaker, whereas our rules demand that after a report has been presented, we will have to wait for 3 days to debate it. I want to move under Rule 6 that will suspend 16 that we suspend 205 and 6 of our rules of procedure.
You're suspending Rule 204.
5 and 6. Yes. That we allow for debate immediately. I beg to move.
Move a motion.
I therefore move a motion, Madam Speaker, that we suspend those two rules, those two clauses, and we immediately debate this motion.
Is that seconded? Seconded by Honorable Silas, Segona, Kato, Pastor, by everybody. Would you speak to your motion?
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, given the importance of the bill, the atmosphere in the House, the willingness of the members, the urgency of the bill, I don't see why we should wait. The gravity of the matter, I don't see why we should wait. We should debate immediately, pass this bill. It is made law so that we have a conducive atmosphere in this country. I beg to move.
I now put a question that Rule 2046 and 5 and 6A be suspended. Those in favor say on the contrary, nay. The ayes have it. Honorable members, as we commence the debate on this motion of the second reading, I wish to guide as follows. As a custodian of rules of procedure, I will defend the right of the minority members, even if the minority have nothing to say, but will defend them. Aware that there is a dissenting opinion from the major opinion, we will accord the minority team an opportunity to first debate and convince the House why they have the minority. I am going to, before we go into a debate, honorable members, when the speaker is speaking, honorable members, I don't want technical errors like what was made before. I am going to do a roll call. We want to confirm the quorum so that the minority member should not run to court that there was no quorum. So, but before we do that, Attorney General has something to say.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, the mandate of Parliament is to legislate. In attending to this bill, Parliament is executing its mandate. My office as Attorney General, we have looked at the bill. We have made consultation with the mover. We have harmonized, and we are comfortable. Thank you.
Thank you. Honorable members. Honorable members, can we now start with roll call? Roll call.
Ababiku Jessica.
Thank you, Right Honourable Speaker. I have listened to your directives, but I request that you guide on members of our committee who are in Karamoja.
I have them on Zoom.
Okay.
I have them on Zoom.
Thank you so much.
Yes.
And I'm present.
Just say present.
Abeja Susan Jolie.
Yes.
Thank you very much, Madam Speaker.
Madam Speaker.
Madam Speaker.
Thank you very much.
I want us to debate once we know that we have quorum.
No, Madam Speaker, I want to invite you and the House
to look at the rule that requires us to have a quorum, Madam Speaker. I know you've looked at it. But that rule requires quorum at the voting stage, Madam Speaker. I want to plead with you that you allow the debate, and then you can ascertain quorum when we are voting, Madam Speaker.
Honorable member, can we have a roll call? We debate and vote. Can we do roll call very fast?
Honorable